Hi friends, today I'll be discussing the California Fair Employment and Housing Act. I will refer to this as the FEHA throughout this segment. This is one of my favorite laws. There's just so much to discuss. So for this segment, I'm just going to do a brief intro and I'm going to outline some of the most common employer mistakes. And in later segments, I'll delve deeper into the act and the history, etc. So, what is the FEHA? This is the primary law that provides employees with protection from discrimination, harassment, and retaliation. This protection extends beyond employees, but it also reaches job applicants as well. So the FEHA comes up in my job in two ways as a defense, labor, and employment attorney in Southern California. One of the ways it comes up is when an employee one of my clients, when an employer gets hit with the threatened action and I have to try to settle before it turns into a full-blown lawsuit. The second way this comes up is when they actually get hit with a lawsuit and then I have to try to settle before trial. And that is because many employers know, typically in California, the juries tend to be sympathetic towards the employees. So when I am representing and defending a company, a corporation, or a nonprofit against alleged FEHA violations, I also get a chance to assist the company by shedding light on areas that they may have overlooked. For example, many companies, especially small ones who have never been hit with a lawsuit, don't know about how to engage in a good faith interactive process when someone mentions that they have a disability or appears to have a disability. This could be physical or mental. And I get to assist the company so that in the future, their chances of getting sued for the same reason are minimized. And I also get to assist the employees by creating and drafting policies for the company. And that has to be one of my favorite parts of my job. So what are the protected classifications under the FEHA? I'm sure we all know about the main ones, race, disability, and things of that nature. But there are more than 10, so I'm going to list them for you. Race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, sexual orientation, or military and veteran status. And there have been some recent major changes stemming from protections of the FEHA in recent years. I think the main ones have come from the protections against race and also sex and gender. So, for example, one of the most recent ones is the Crown Act, and this extends the FEHA protections against race discrimination. It provides that it is expressly prohibited to discriminate based on natural hair and hairstyles, including braids, locks, twists, and hair texture. And then other protections have stemmed from the Me Too laws, and these extend from FEHA's protection against sex and gender discrimination and harassment and sexual harassment in the workplace. One of these, which I'm personally, just as a mom, so excited to see this, the Lactation Accommodation Law. This shouldn't even be a law. This should just be common sense, but I understand for small employers, it's probably difficult to make means to accommodate the Lactation Accommodation Law. However, there are some exceptions. I'm not going to get into the details. Maybe I will later, but essentially, the Lactation Accommodation Law provides that businesses are required to provide a room with certain accessories for lactation. And then there's also the Stand Against Non-Disclosure Agreements law provision that was just created as well. And this prohibits non-disclosure clauses in settlement agreements involving sexual assault and harassment and discrimination. That's a good one too. Okay, so let's get into common employer mistakes. I think most of the common employer mistakes that I'm familiar with and that I've seen that are related to the FEHA are those that have been made regarding disability. For one, a lot of my clients, well, I won't say a lot, but too many of my clients have just made the assumption that they know what a disability is and what a disability is not. And from there, they take actions that have actually proved to be detrimental to them in the future and result in lawsuits and threatened actions. So my advice is always consult with an attorney. Don't assume that something is a disability or it is not. The second most common employer mistake is just not taking complaints seriously. I think that this also meshes with not offering light duty or not engaging in the interactive process. This could easily be separated into 3 common mistakes, but I'm bunching them all together. The law provides that it requires that an employer must engage in a timely, good faith interactive process when presented with the request for accommodation. A presentation of a return to work note from a doctor with restrictions is often sufficient to constitute a request for accommodation. So I've seen policies at companies where they have a 100% recovery return to work requirement. That is totally unacceptable. That is a violation of the law. That's a violation of the FEHA. Remove this policy if you have it immediately. Not offering light duty, that's unacceptable as well. You have to engage in the interactive process. Another unfortunate common mistake that I've seen that results in lawsuits is terminating employees after they've exhausted their Sephara or Fmla leave time, or terminating an employee when they return from their leave. I understand that if you have good documentation and there's a non-discriminatory motive behind the termination, that it could be found valid, but the likelihood that you're going to be hit with a threatened action or a lawsuit is just higher if there's a close proximity between the time they've engaged in the protected activity, such as taking leave, and then getting terminated shortly thereafter. And lastly, quid pro quo arrangements. Just don't do it. That's my advice. Just don't do it. If you don't know what quid pro quo is, it's just requesting sexual favors or making romantic gestures in exchange for promotions or other work benefits. And I do have to say it because it happens. Just don't do it. All right.